Hello everyone. Today I'll be discussing about formation of contract, offer and acceptance. First I'll go for the introduction, then the offer, acceptance, revocation of offer, conclusion. Contract law was enacted on 25th April 1872. It was based on English common law principles. Different religions had different customs and thus there was a need to unify and codify laws related to contract, and that's why contract law was enacted in the year 1872. Manusmriti, Yagnavaikalya Smriti, Arthashastra, Mitakshara were some of the texts under Hindu law which dealt principles related to contract. Manusmriti contained contracts law, and the contracts were divided into four categories: agreement with respect to immovable property, debt agreement, agreements of homage, ordinary agreements. Laws of Manu contain provisions requiring parties to a contract to follow customs and traditions of a locality. Arthashastra contain provisions related to interpretation of contract, especially the rule of strict rule. Smritis contain provisions emphasizing on proper execution of contracts. And Mohammedan law had three concepts: Ribha, Garar, Maisir. Riba meant interest. So interest levying was prohibited under the Sharia law, and gharar meant uncertainty. Any sort of uncertainty with respect to contract was prohibited under the Sharia law. And maisir, which dealt with speculation. So any sort of speculation in contracts that was prohibited under the Sharia law. There are three types of contracts under Muslim law: contracts leading to permanent transfer of ownership, partial transfer of ownership, and no transfer of ownership. The concept called as Al-Kharar bi Daman was introduced, which stated that a person, if he wants to earn profits, he must bear losses too. And the Muslim law also suggested remedies for contractual breach, and it was limited to direct and actual damages. And there were provisions with respect to act of God also, and it stated that if the vitiation of contract happens due to act of God or vis major, no damages had to be paid. So section 10 of Indian Contract Act states that agreements are contracts if they are made based on free consent of parties, and there is competency of parties, and there is lawful consideration, lawful object, and the agreement should not be expressly declared as void. So agreements have to have consensus ad idem. For example, let us suppose that today I am stating that I am going to sell Honda City car, that too 2020 model, but my friend assumes that I will sell to 2025 model and not 2020 model. There is no meeting of minds. There is no consensus ad idem here. So agreements require the parties to a contract, that is the offerer and the offeree, to have consensus ad idem. So there should be bilateral act and not unilateral act. For example, if there is a arbitration clause in a contract, and if the other party doesn't know about the arbitration clause, it will be a unilateral act that is not envisageable under the Contract Act. Offer has been defined under Indian Contract Act as when one person signifies to another their willingness to do or abstain from doing something with the intention of obtaining the other person's assent to such act or abstinence. The key elements of an offer are willingness to act, directed to another person, seeking consent. There are two types of offers: express offer and implied offer. If A offers to sell his bike for 10 lakhs to B, then it is an express offer. In a restaurant, It is an implied offer that the restaurant will keep about consuming food, and at the end of the meal we have to pay for it. So that is an example for an implied offer. So an offer is made either to a individual or to the public at large. If it is made to an individual, then that is a specific offer. A promises to pay rupees 10,000 to B for returning his lost horse, then that is a specific offer. If A states that he shall be giving 10,000 as a reward to anybody who finds his missing horse, then that is a general offer. Offer has been further classified as positive and negative offer. If there is an offer for construction of a well for privacy, then that is a positive offer. Then, if there is an offer not to constitute a wall to allow free passage of light and air, then that is a negative offer. Cross offer does not constitute a valid offer. If A states today that he wants to sell his bike to B for 10,000 rupees and B states that he wants to buy it for 9,500 rupees, then that does not constitute a valid offer. That is the cross offer, and that is not permissible under the Indian Contract Act unless A agrees to it. So, an essentials of a valid offer are: it must be capable of creating legal relationship. For example, let us suppose that you have a friend who has graduated from law college and she wants to host a dinner party for her professors, and none of her professors turn out to the dinner and she is used for damages. So is this permissible or not? It was just an invitation for offer, and it did not create any legal relationship, and that's why invitation for a dinner or any party or as such does not create legal relationship, and that's why it will not constitute an offer. Offer must always be certain, definite, and not vague. For example, if A says to B, I may sell you my car someday if I like it for a good price, this is uncertain, vague, and there is no intention to be bound. If A says to B, I offer to sell my Hyundai i10 car, that too 2020 model, for 4 lakhs. Offer is valid until August 31st. Then this is a valid offer with certainty, definiteness, and it is not vague. Certain cases which have to be discussed when it comes to offer. First one is Upton on Swan, RDC versus Powell. In this, the defendant's firm caught fire. The defendant believed that he was entitled to free services if fire broke down. The defendant's firm was not within the free zone of Upton services, and hence the defendant was held to be liable to pay for the services rendered. In Ramji Dayawal and Sons Limited versus Invest Impact, a contract was entered between India and Yugoslavian party, and the terms contained that arbitration would be performed by International Chamber of Justice in Paris. The Indian party wrote its objection to it, and the Yugoslavian party did not reply but went forward with the work. It was held that in case of dispute, the matter would be tried before the court of law, and it was implied in nature. The communication is complete when it comes to the knowledge of the offeree. In Lalma Shukla versus Gauri Dutt, defendant's nephew absconded from home. He sent his servant in search of the boy. The defendant, after the servant left, announced the reward of 500 rupees to anybody who found the missing boy. The servant came to know about the reward after the boy was traced. Action was brought to recover the reward. It was held that there was no acceptance unless there is a knowledge of offer. There should always be an intention to contract. In Balfour versus Balfour, the husband had to go to Ceylon on work obligations, and the wife stayed back in England due to health reasons. The defendant agreed to send an amount of £30 every month to the wife. The defendant sent the amount for some time, but he stopped sending the amount for after some time. As differences arose and the parties separated, the wife brought an action to recover the £30 agreed by the defendant. But this was held to be an ordinary agreement as it did not result in any legal obligation. Mere opening of joint accounts and the man's promise to buy new car to improve the strained relationship with the wife all constitute domestic arrangement, not capable of creating a legal relationship. In Banwari Lal versus Sukhdarshan Dayal, loudspeakers spelled out terms of sale in which it stated that plot of so and so dimension would be reserved for building a dharamshala, but the plot was sold for private purpose. It was held that this was a mere puff to upscale the property. In Carlyle versus Carbolic Smokeball Company, there was an ad by the Carbolic Smokeball Company stating that £1,000 would be saved in the bank account of the defendant company if the drug did not cure influenza. Carlyle consumed the drug and it did not cure her influenza. So she brought an action to recover the £1,000 amount. It was held that this was a mere puff and it was an invitation to offer and not an offer per se. We have understood offer, let us understand acceptance. Acceptance has been defined as when the person to whom proposal has been made signifies his assent thereto, the offer is said to be accepted. Here, the communication should be made to the offerer himself. Let us suppose that an uncle states that he wants to buy his nephew's horse, and the nephew comes up with a statement stating that if I hear no more from anybody, the horse will be construed as sold to at 20k to my uncle. Here, the nephew intended to sell the horse and it was not communicated to the uncle. The offerer cannot impose upon the offeree the burden of refusal. In Powell versus Lee, the headmastership position of a school was vacant. The managers passed a resolution appointing the plaintiff. The decision was, however, not communicated to him. One of the members, in his individual capacity, informed the plaintiff. The resolution was nevertheless cancelled. Plaintiff sued for breach of contract. Here, it was held that the acceptance was not complete, as the acceptance was made through an unauthorized person. A offered to buy flour from B, requesting that acceptance should be sent by wagon, which brought the offer. But B sent the acceptance through post, thinking that it would reach speedily, and the letter arrived later. A was held not bound by the acceptance. Complete contract arises on the day when the letter of acceptance is posted in due course. Section 4 states that the communication is complete when the letter is posted and out of power of the acceptor. As against the promisee, it is when the promisee has dispatched his letter of communication of acceptance. Contract is concluded at the place where the proposal is accepted, and communication of acceptance is dispatched at the address at which the proposal was sent. The accepted becomes bound only when the acceptance comes to the knowledge of the proposer. In Bhagwan Das Kedia versus Giridhari Lal Purushottam Das and Co., whether telephonic communications were part of Section 4 of Indian Contract Act 1872 was discussed, in which Justice Shah held that the draftsman of Indian Contract Act did not envisage the use of telephone and it was not invented. The communication was confined to posts only. But Hidayatullah Justice stated that Section 4 was flexible enough to include telephonic communications, and that's why Section 4 includes even emails today. Acceptance should always be absolute and unqualified. In Hyde versus Wrench, an offer to sell firm for £1,000 was rejected by the plaintiff, and a counter offer was made at £950. There existed no obligation of any sort between the parties, as this was a case of counter offer and not of actual offer. Partial acceptance is not permissible. For example, if A wants to buy company, he has to purchase shares. And there is also a clause stating that the offeree would also become the cashier of the firm. Here, if the former part of the contract is performed and not the latter, there is partial acceptance and that is not permissible. Counter proposal, as stated earlier, is not proposal and acceptance. When a counter proposal is accepted, a contract arises in terms of counter proposal and not in the terms of original offer. Acceptance can always be made subject to final approval. Revocation of offer happens through four ways. First one is communication of notice of revocation by proposal. Then second one is by lapse of time prescribed for its acceptance. Failure to accept condition precedent. By death, insanity, declared insolvent. Let us suppose that X comes with a notification stating that he wants to sell his car to B for 10 lakhs by August 31st. But B accepts the offer after 31st. Here there is revocation of offer and there is a lapse of time, as the time was before 31st itself. Let us suppose that a salt lake was to be brought along with a deposit of certain sum of money. Here the former was complied but the latter condition was not complied with. Here there is failure to accept condition precedent. An offer to constitute valid offer, it has to satisfy three conditions. First one is there should be a willingness to act. Then it should always be directed to another person, that is the offeree, and then there should be consent. For an acceptance to constitute valid one, it has to be communicated to the offerer himself, and it should be an overt act of acceptance and not mere mental determination. These are the fundamentals when it comes to offer and acceptance. Do let me know what are the next concepts that I'll have to teach. Thank you for listening to my lecture.